registration, you were stopped for violating the code.
Officer, the code you're referring to only applies to commercial vehicles. This is
Don't start arguing with me. I know the law.
I'm not arguing. I'm explaining that the statute doesn't apply here.
So now you're a legal expert.
Actually, yes, I'm an attorney.
Watch your tone.
No legal basis.
You're making this harder.
At exactly 7:18 p.m. on a quiet suburban road in Memphis, Tennessee, a traffic stop that should have lasted 4 minutes became a career-ending encounter for one police officer and a defining moment for a 21-year-old who had spent 3 years preparing for exactly this kind of conversation without knowing it. The body camera footage, time-stamped, recorded in high definition, captured from the chest of Officer Wilson Davis himself, would later circulate across every major social media platform and spark debates in law school classrooms, civil rights organizations, and police oversight committees simultaneously. But this was not a typical police encounter video. This was a first-year lawyer standing on the shoulder of a residential road at dusk in a green tank top and jeans, calmly and methodically dismantling every procedural justification an officer attempted to construct, in real time, on his own camera, using the exact legal framework his department required him to know and had apparently never confirmed that he did. What happened in the next 19 minutes would embarrass a precinct, expose a pattern, and prove that the most dangerous person in a traffic stop is sometimes the one without the badge. Before we continue, drop your city or country in the comments right now, and if you haven't subscribed yet, do it before this video ends. This story gets more consequential with every minute, and you will not want to miss how it ends. Maya Thompson was not your average 21-year-old. While most people her age were navigating their first years out of school with the particular uncertainty of someone who has credentials but not yet experience, Maya was already doing what most law school graduates spend years working toward, applying constitutional law in the field, in real time, under pressure, without notes. She had graduated from the University of Memphis at 20 with a degree in political science and a concentration in constitutional studies that her academic advisor had described in her graduation letter of recommendation as the most rigorous, self-directed curriculum he had supervised in 19 years of teaching. She had entered law school at 21, the youngest student in her cohort, and had spent her first year immersed in Fourth and Fifth Amendment jurisprudence with the specific focus of someone who understood that these were not abstract legal principles. They were the rules governing what police could and could not do to a person on a public road, and she had encountered those rules in practice before she encountered them in a textbook. She specialized in stops and seizures, Terry versus Ohio, Rodriguez versus United States, Illinois versus Cabales. She had briefed each case, argued each standard, and could recite the reasonable articulable suspicion threshold in her sleep with the particular fluency of someone who had spent a year making it automatic. Her professors had stopped calling on her during Fourth Amendment discussions, not because she was unprepared, but because her preparation tended to preempt the discussion entirely. On that particular evening in September, Maya was driving home from the law school library, a Tuesday night study session that had run 2 hours longer than planned because the brief she was drafting refused to resolve itself cleanly, and she had the specific stubbornness of someone who does not leave a problem unfinished. The sky over Memphis had gone the deep blue of early dusk, the kind of blue that arrives in the 20 minutes between sunset and full dark and makes the streetlights look like they've just remembered to come on. Maya had her music playing, her windows cracked, the particular decompression energy of someone whose mind was still half in the brief and half in the drive home. She was not speeding, she was not on her phone, she wasn't weaving or running lights or doing anything that the Tennessee Traffic Code recognized as a violation. Her car, a dark sedan, registration current, insurance active, tags visible and valid, was moving exactly as a car is supposed to move on a residential road at 7:18 p.m. on a Tuesday in September. Then the lights came on behind her. Red and blue in the rearview mirror, cutting through the early evening blue with the specific visual authority that those lights carry regardless of what preceded them. Maya's response was not panic. It was the immediate, methodical mental review of the last several miles of driving, the kind of review that a first-year law student specializing in stops and seizures runs automatically, like a diagnostic, because the first question in any Fourth Amendment stop analysis is whether the stop itself was lawful, and that question begins with what the officer observed before activating the lights. She reviewed the last several miles, She found nothing. She pulled to the shoulder, cut the engine, and placed both hands on the steering wheel where the approaching body camera could see them clearly. She was wearing a dark green sleeveless tank top, light-wash jeans with a black belt, hoop earrings catching the blue and red light from behind her, the tattoos on both arms visible in the dusk, detailed, considered ink that ran from her forearms towards her shoulders on both sides. Her braided hair was pulled loosely, a few strands catching the light. Her phone was in her left hand, screen face up on her lap, because she had made a decision somewhere between seeing the lights and reaching the shoulder that she was going to document this interaction from the moment it began. She was 21 years old. She had been studying the law that governed this exact moment for a year, and Officer Wilson Davis, Unit 35, was about to discover that the young woman he had pulled over on a residential road at dusk had spent considerably more time preparing for this conversation than he had. Officer Wilson Davis had been with the Memphis Police Department for 9 years. His personnel record contained the standard language of an officer whose performance reviews had never been extraordinary and whose complaint record had never been addressed as a pattern. 3 civilian complaints in 9 years, each reviewed individually, each closed without disciplinary action, none of them ever placed side by side and asked what the sequence meant. He worked the evening shift on the residential corridor that ran through the eastern suburban neighborhoods and had developed, over 9 years, the kind of enforcement instincts that his supervisors described as proactive and that his complaint record described in a different vocabulary entirely. He had been following Maya's sedan for 6 blocks before activating his lights. His dash camera had been recording for all 6 of them. The footage showed a vehicle maintaining its lane, observing every light, traveling at or below the posted limit for the entire 6-block observation window. There was no articulable violation in any of the 6 blocks. There was a young black woman driving alone at dusk in a neighborhood that Wilson Davis had patrolled for 9 years, and there was a decision made somewhere in those 6 blocks that the body camera was going to spend the next 19 minutes documenting in the kind of detail that a first-year law student specializing in stops and seizures would later describe in a formal complaint with precise statutory citations and case law references as a textbook violation of the Fourth Amendment's reasonable articulable suspicion standard. He stepped out of his cruiser. His body camera was active. The timestamp read 17:18:42. He had no idea what the next 19 minutes were going to cost him. Davis told her the reason for the stop. He said she had an air freshener hanging from her rearview mirror that constituted an obstruction of her view under Tennessee traffic code. The air freshener in question was a small cardboard rectangle, the standard issue kind available at every gas station in the country, approximately 2 inches by 1 inch, hanging from the mirror on a thin string and obstructing approximately the same amount of the windshield's view as a grain of rice obstructing a movie screen. Maya looked at the air freshener. Then she looked at Davis. Then she did something that the body camera recorded with the kind of audio clarity that made the subsequent 9 minutes of footage entirely self-explanatory. She asked him to cite the specific Tennessee statute. Not aggressively, not with the confrontational energy that the question might carry in the mouth of someone trying to provoke a reaction. She asked it the way she asked questions in constitutional law seminars, directly, precisely, with the genuine expectation of a specific answer, because a specific answer was the only kind that mattered, and she had spent 3 years learning the difference between an answer and a response. Davis said it was standard traffic enforcement. Maya said she understood that and asked again for the statute number. The body camera recorded the pause that followed, 2 seconds of Davis's breathing, the Memphis evening behind him, the blue and red lights still turning on the residential street before he moved to his second approach. The obstruction justification had lasted approximately 90 seconds before someone 6 days into their legal career had asked the one question it couldn't survive. The lesson already writing itself into the body camera footage at 7:20 p.m. was not about air fresheners or rearview mirrors or Tennessee traffic code. It was about the difference between a justification and a reason, between the thing an officer says to establish the basis for a stop and the thing that actually constitutes one. Davis had arrived with the first kind. Maya Thompson had spent 3 years studying the second, and the gap between them was about to become 19 minutes of footage that no subsequent report was going to be able to close. Davis cited the statute on his second attempt. He produced it the way people produce things they have retrieved under pressure, with the surface confidence of someone presenting an answer and the underlying uncertainty of someone who is not entirely sure the answer is going to hold up to the question that follows it. Tennessee Code Annotated 55-9-107. He said the code number with the specific authority of someone who had used it before and had never been asked what it actually said. Maya knew what it actually said. She had encountered TCA 55-9-107 in her first year of law school during a Fourth Amendment seminar that spent 2 weeks on pretextual stops, the legal practice of using minor traffic violations as justification for stops that have a different, unarticulated motivation underneath them. The statute addressed obstructions that materially impaired a driver's view. The operative word, which Maya's seminar professor had underlined in the course materials and which Maya had underlined again in her own notes, was materially. Not any object within the windshield's general vicinity, not a standard 2-inch air freshener on a string, an obstruction that materially, measurably, demonstrably, substantially impaired the driver's ability to see the road. She explained this standing on the shoulder of a Memphis road at dusk in a green tank top, without notes, citing the material impairment standard from memory, with the calm precision of someone reciting something they have said enough times that it no longer requires effort. Davis told her that was his interpretation of the statute. Maya said, with the same level tone she had maintained since he reached the window, interpretation required the object to meet a threshold his citation didn't support, and that 3 controlling cases in the Sixth Circuit had applied the material impairment standard in a way that excluded objects of the air freshener's size and placement from the statute's scope. She named the cases, she cited the years, she gave him the holdings in 1 sentence each, not to perform her knowledge, but because the holdings were the relevant information, and relevant information was what the conversation required. The body camera recorded Davis's expression through the entire recitation. It was the expression of a man receiving information he had not anticipated from a source he had not accounted for. Not angry yet, not defensive yet, but operating at the edge of the framework he had arrived with, feeling its strain under the weight of a 21-year-old attorney who had spent a year making this exact legal standard automatic. He told her she was making this more complicated than it needed to be. She said she was making it exactly as complicated as the statute required, no more, no less. The roadside classroom was in session. Davis hadn't realized he was enrolled until the second case citation landed, and he had nothing left to do with it except stand on the shoulder of the road and wait for the third. Davis made his next move at the 7-minute mark. He told Maya he was going to need her to step out of the vehicle. He said it with the tone of someone who decided that the conversation needed a reset, that removing her from the car would redistribute the dynamic in the way that the last 7 minutes had failed to produce from his position at the window. The instruction was delivered as though it were procedurally routine. It was not. A minor equipment citation, even a valid one, does not carry a legal basis for requiring a driver to exit the vehicle absent specific, articulable safety concerns or independent grounds for suspicion. Maya knew this. The body camera was about to record exactly how well she knew it. She did not reach for the door handle. She asked him, in the same measured tone that had not changed register once in 7 minutes, whether he had reasonable articulable suspicion of criminal activity beyond the equipment citation that would legally support a request to exit the vehicle. Davis said he didn't need to explain himself. Maya said, with the patient precision of someone correcting a factual error rather than winning an argument, that Terry v. Ohio established in 1968 that an officer must be able to point to specific and articulable facts that warrant the intrusion. That reasonable suspicion was not a feeling or a preference, but a constitutional standard with a 57-year-old legal foundation that his department's own use of force policy incorporated by reference. She said Terry v. Ohio the way her professors had taught her to say case names, not as a performance of knowledge, but as a citation, the way you cite the source of a fact when the fact is being disputed. Davis told her she was being uncooperative. She told him she was being precise, and that the distinction mattered because uncooperative described a behavior and precise described a standard, and the standard was what governed whether his instruction had a legal basis rather than whether she personally chose to comply with it. The body camera captured the specific quality of silence that followed, the silence of a man who has been told something he cannot argue with by someone he had not expected to be able to argue at all. 9 years of enforcement experience had not prepared Davis for the particular experience of having his own academy training explained back to him accurately on a residential road at dusk by a 21-year-old in hoop earrings who had passed the bar 6 days ago and had not raised her voice once. He reached for his radio. The roadside classroom had just added a new subject to the curriculum, and Davis, who had failed the first 3 modules without realizing he was being assessed, was about to find out that calling for backup did not excuse you from the examination. The backup officer arrived at 7:31 p.m. His name was Sergeant Aaron Mitchell, 12 years on the force, the kind of institutional experience that produces, in people paying attention, a reliable instinct for walking into situations and reading them accurately before anyone speaks. He stepped out of his cruiser, assessed the scene in the specific way that supervisors assess scenes they were not present for, and walked toward Davis's position at the window with the measured pace of someone who had already begun forming a picture from the available evidence. A stopped vehicle with no visible damage, a young woman standing composed beside her open door, a body camera running on his officer, and the particular energy of an interaction that had been going on long enough to produce its own atmosphere. He asked Davis for a brief summary. Davis's summary lasted 40 seconds and covered the air freshener citation, the request to exit the vehicle, and the driver's responses, the last of which he described as uncooperative and legally argumentative. Mitchell listened without interrupting. Then he looked at Maya for the first time, directly, with the evaluative attention of a supervisor conducting an on-scene assessment rather than a social introduction. Maya met his gaze with the same composed steadiness she had maintained for 13 minutes. She didn't speak. She didn't need to. Her phone was still recording on the passenger seat. The body camera was still running on Davis's chest, and the expression on Mitchell's face as he processed the 40-second summary against what the scene in front of him actually looked like carried the specific quality of a man arriving at a conclusion he wasn't going to enjoy delivering. He asked Davis, quietly, what the articulable basis for the exit request had been. Davis said the driver had been uncooperative during a lawful stop. Mitchell asked him to be specific about the uncooperative behavior. Davis couldn't be specific, because the specific behavior was a 21-year-old attorney citing case law accurately on a residential road at dusk, which was not a behavior that any honest articulation of department policy could classify as grounds for escalation. The specificity Mitchell was asking for didn't exist in a form that would survive being said out loud on a running body camera in front of a 12-year sergeant who had just asked the question. The silence that followed Davis's inability to answer was the most consequential silence of his 9-year career. It lasted 4 seconds, it was recorded in full, and it communicated, without requiring a single additional word from anyone on that shoulder, exactly what 13 minutes of body camera footage had already established, that Davis had arrived at a stop without a sufficient legal basis, escalated it without articulable grounds, and was now standing on the shoulder of a Memphis road at 7:31 p.m. with a supervisor asking him to justify his decisions and a licensed attorney standing 3 feet away who could explain precisely why he couldn't. Mitchell turned to Maya. He apologized for the duration of the stop. He told her she was free to go. Davis stood beside his cruiser and said nothing. The lesson that the shoulder of that road delivered in that moment was not delivered through argument or volume or the accumulated force of 19 minutes of legal recitation. It was delivered through the 4-second silence of a man who had been asked to articulate his basis and had discovered, in real time, with a running body camera and a 12-year supervisor waiting for the answer, that the basis had never existed in a form that the law recognized. Maya picked up her phone from the passenger seat. She checked that the recording was saved. Then she got back into her car with the unhurried composure of someone who knew since the 7-minute mark that this was exactly how it was going to end. Maya filed the formal complaint at 9:14 p.m. Not the following morning, not after a consultation period or a night of deliberation about whether the effort was proportionate to the outcome. 2 hours after Mitchell told her she was free to go, she was sitting at her desk in her apartment with the body camera footage, preserved from her phone recording and formally requested from the department under Tennessee's public records statute within 30 minutes of leaving the shoulder, open on her laptop, and a complaint document that she had drafted with the specific precision of someone who had spent a year learning exactly how these documents needed to be constructed to survive the internal review process without being reduced to a he said, she said resolution. She was 6 days into her legal career. The complaint read like it had been written by someone 6 years in. The formal submission went to the Memphis Police Department's Internal Affairs Division and, simultaneously, to the Tennessee Human Rights Commission. The simultaneity was deliberate. The same strategic thinking that had guided her through 19 minutes on the shoulder informed the filing strategy. Internal Affairs alone would place the matter inside the department's own review structure, where 3 prior complaints against Davis had each been processed individually and closed without producing a pattern finding. Filing with both ensured that an external body with independent jurisdiction was reviewing the same evidence at the same time, which meant the department's ability to manage the outcome quietly was structurally limited before the review began. The civil rights lawsuit was filed 11 days later. Maya's supervising partner at the civil rights litigation firm had reviewed the body camera footage on the morning after the stop. Maya had sent it at 9:47 p.m. the previous night with a 3-paragraph summary that her partner later described as the clearest incident brief she had received from any attorney at any experience level in 14 years of practice. The lawsuit named Davis personally and the department institutionally, claiming racial profiling under the Equal Protection Clause, unlawful seizure under the Fourth Amendment, and a pattern of selective enforcement supported by Davis's 3 prior complaints, now obtained through discovery and laid side by side as a sequence for the first time. The deposition was scheduled 3 weeks after the filing. Davis arrived with a department-appointed attorney and a prepared account of the stop that the body camera footage contradicted in 11 specific places, each one identified, time-stamped, and cross-referenced in the deposition exhibit package that Maya had assembled herself. She sat across the table from Davis for the first time since the shoulder of the road and asked her first question with the same level, unhurried tone she had used at the window. She asked him to explain, in his own words, what specific and articulable facts had supported his reasonable suspicion at the time he activated his lights. The question was the same one she had asked on the shoulder. The setting was different. The body camera footage was Exhibit A on the table between them, and Davis's attorney, who had reviewed the 11 contradictions in the exhibit package before the deposition began, placed a hand on his client's arm before he answered and asked for a 5-minute recess. The lesson that deposition table delivered was the same one the shoulder had delivered 19 minutes into a Tuesday evening stop, that the most consequential preparation happens before the encounter, not during it. Davis had 9 years. Maya had 6 days and 3 years of deliberate study. The difference between them was not experience. It was the specific, disciplined investment in understanding the rules that governed the encounter before the encounter began. Davis had enforced those rules for 9 years without fully understanding them. Maya had studied them for 3 years without yet having the license to apply them professionally. On the evening of September 14th, she had applied them anyway, on a shoulder, in a green tank top, without notes, and the deposition table was where the application became permanent. Wilson Davis was dismissed from the Memphis Police Department 31 days after the stop on the residential corridor. The internal affairs finding came first, a formal determination that the stop lacked reasonable articulable suspicion, that the exit request had no lawful basis, and that Davis's conduct was consistent with a pattern of selective enforcement that 3 prior complaints, now reviewed as a sequence for the first time in 9 years, had been documenting without anyone connecting the sequence to a conclusion. The finding recommended termination. The department's review board adopted the recommendation without modification. Davis's 9-year career ended in a written decision that cited the body camera footage 14 times in 4 pages and required no editorial commentary beyond the timestamps. The civil rights lawsuit settled 6 weeks after the termination. The settlement figure was not disclosed at Maya's request, not because she wanted to minimize the outcome, but because she had decided that the number was the least important thing the case had produced, and she did not want it to become the headline that displaced everything else. What she asked to be disclosed, and what the settlement agreement made part of the public record at her insistence, was the department's commitment to mandatory Fourth Amendment refresher training for all active officers, an annual review protocol that examined each officer's stop records for demographic patterns rather than individual incidents, and a formal revision of the complaint review process that required complaints against the same officer to be assessed as a cumulative record rather than isolated events. Those three provisions were the outcome she had been building towards since 9/14 on September 14th. The settlement figure was the mechanism. The provisions were the point. Maya returned to work at the civil rights litigation firm on the Monday following the settlement. Her supervising partner had cleared her afternoon schedule and suggested she take the day. Maya had thanked her and come in anyway because the brief she had been drafting on the evening of the stop still needed finishing, and she had never been comfortable leaving problems unresolved. She finished it that Monday, filed it Tuesday, won the motion on Friday. She gave one public statement after the settlement, not a press conference, not a media appearance, but a written statement posted to the firm's website that her supervising partner had reviewed and returned without a single suggested edit. It covered exactly the ground Maya had been thinking about since she watched the blue and red lights appear in her rearview mirror on a Tuesday evening and ran the Fourth Amendment diagnostic before she had fully processed the emotional register of what was happening. She said that knowing your rights was not an academic exercise. It was not the exclusive province of law students or attorneys or people who had access to 3 years of constitutional law seminars. It was the practical, accessible, non-negotiable foundation of every interaction between a citizen and the state. And the gap between people who carried that knowledge into those interactions and people who didn't was not a gap in intelligence or capability. It was a gap in access. Access to information. Access to the specific vocabulary that converted a constitutional protection from an abstract principle into a usable tool in the moment the tool was needed. She said that on September 14th, she had been fortunate. She had the vocabulary. She had the case law. She had 3 years of deliberate preparation that had made the reasonable articulable suspicion standard as automatic as her own name. Most people pulled over on residential roads at dusk do not have those things. They have rights, the same rights, under the same Constitution, protected by the same 57 years of Fourth Amendment jurisprudence, but without the vocabulary to name them in the moment, those rights exist in theory, while the encounter on the shoulder of the road proceeds on someone else's terms. She said that was the thing she wanted the footage to leave behind. Not the dismissal, not the settlement provisions, not the 19 minutes of a police officer being corrected on his own academy training by a 21-year-old on a Memphis roadside. Those were outcomes. The thing she wanted to last was the understanding that the law was not a specialized instrument available only to people with bar licenses and law review publications. It was a public document, written in accessible language, available to anyone willing to read it. And the single most effective thing any citizen could do with it was know it before they needed it, because the moment you needed it was never the moment you had time to learn it. She said Terry versus Ohio was 57 pages. The reasonable suspicion standard was 2 sentences. 2 sentences that every person who had ever been pulled over on a road they had done nothing wrong on deserved to know by heart. Davis's name was removed from the department's active roster on the 31st day. His body camera equipment was returned to the property room. The footage from September 14th was retained as a training exhibit, not for the civil rights litigation seminar or the Fourth Amendment module, but for the department's new intake orientation, shown to every incoming officer on their first day before they were issued a badge or a camera or a patrol assignment. It was shown without commentary, because after 19 minutes on a residential road in Memphis, the footage had learned to speak for itself. Maya Thompson still drives the same route home from the law library. Same road, same stretch of residential corridor where the blue and red lights had appeared in her mirror on a Tuesday evening and she had run the diagnostic and found nothing. She drives it at exactly the speed limit, not from anxiety, but from the particular discipline of someone who understands that the law is not an obstacle to navigate around, it is the road itself. And she had spent 3 years learning every inch of it before she ever needed to stand on its shoulder and prove she knew the way. If this story held you from the first blue light in the mirror to the last sentence of Maya's statement, if it made you think about what you would say at the window, about whether you know the 2 sentences that could change the outcome of a stop, about what changes when the person being pulled over has spent 3 years preparing for the conversation, share it with someone who needs to hear it. Stories like Maya Thompson exist because a 21-year-old passed the bar on a Wednesday and got pulled over the following Tuesday and knew exactly what to do with every second of it. We tell them because the people who don't have 3 years of Fourth Amendment seminars deserve to know that the protection exists and that the vocabulary to claim it is available to anyone willing to find it. If you want more stories about accountability, legal rights, and the people who refuse to let the encounter proceed on someone else's terms, hit that like button right now, subscribe to this channel, and tap the notification bell so you never miss a video. We post stories exposing racial profiling, police misconduct, and the moments when knowledge became the most powerful thing in the room. Every story is documented, every one matters, and we are nowhere near finished telling them.